Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest news on privacy, data protection, cybersecurity, and crisis management related to technologies from all over the world. Today with me, I have Stephen Matthias, head of the Bangalore office of the law firm Kochhar, which is one of the most and prominent law firms for what concerns technologies. And I'm particularly pleased to have Stephen with us as co-chair of the technology law practice in the firm, in order to discuss about data protection related news, which is the implementation of the new Indian Data Protection Board, which came into force in the course of the month, exactly 13th of November, bringing some news from India that we should surely know about. So, Stephen, which are the key elements that these news are bringing at the moment?
Hi, Alessandro. Thanks for having me again. Yes, so India had actually enacted the Digital Personal Data Protection Act in August of 2023, so more than 2 years ago, and had not implemented the statute. The main reason was the government was working on preparing rules that would implement the statute. It did issue draft rules and then was working on finalizing those rules. So what happened recently was a bunch of things. One is the government notified the statute, which is required for the statute to come into force. Provisions relating to the Data Protection Board of India, which is India's data protection authority, those have come into force already. The board has not yet been constituted, but now the government has the statutory power to constitute the board. Then it notified that 1 year from the date of notification, which would be November 13th, 2026, the provisions relating to consent managers would come into force. And then 18 months from the date of notification, which will be May 13th, 2027, the remainder of the statute would come into force. So for data controllers and data processors involved with personal data in India, the magic date is really May 13th, 2027, when the law will come into force and everybody needs to comply.
Thanks a lot for giving us this snapshot on what's the stage in India. I think it would be relevant to remind our listeners, about the law in India and about the capabilities of this board that is now going to be formed in the coming month. So can you just refresh us on which are the key elements of the Indian data protection law, and also which is the role of the board in this context?
Sure. So, by and large, you could say that the DPDPA, as it's referred to, is a fairly simple law. It's not as detailed, not as comprehensive as GDPR. And that's a good thing because this privacy law is really new for India. And it would be hard for, especially smaller, medium-sized businesses to comply if there was a lot there in the law as much as, say, GDPR. Having said that, it does differ from GDPR in some significant ways. The key one is that there is no ground such as legitimate interest. There are two types of exemptions. One are exemptions from the requirement of obtaining consent, and there are a few there. And there are other exemptions from the statute itself. But by and large, for most uses of personal information, consent is the only ground of processing. And the standard of consent is the same as under GDPR. It must be, consent must be freely given, unconditional, through an affirmative action, and so on. And the language being almost the same as under GDPR, one might conclude that the jurisprudence that's developed in the EU, especially guidances from the EDPB, might well be considered in India as well. So that's a fairly high standard. So I think that's one very significant difference. It probably means that privacy policies and notices, which are GDPR compliant and which use legitimate interest as the main ground, would not work in India because you need to get consent. And in addition to that, under the rules, the government has gone further to implement GDPR type consent standards, where you need to disclose for what service or goods the personal information is being collected, what personal information is being collected, and for what purpose. And you have to give it somewhat in an indexed form. So that's very significant, and that I think that's the biggest really real difference between this law and many other laws worldwide. There are a few other things. For example, the data breach provisions are quite stringent as well. There are essentially four stages of data breach notifications. One is under our, you know, cybersecurity law, which the Cybersecurity Authority, then two notifications, the Data Protection Board of India, and then one to data subjects. And there's no threshold, no standard like based on harm or risk and so on. You've got to notify every breach. So I think I would point out these two are very significant differences in the Indian law.
Perfect. Thanks a lot, Stephen, again, for also updating us on that. And my other point was, again, related to the news. How does the DPA fits into this scenario? So which would be the role of the board in India we were talking about at the beginning?
So they've got, in my opinion, they've got some of it right and some of it wrong. What they've got right is to have a very simple law. And, there's talk about how many times the law says as may be prescribed. I think it's actually a good thing because it helps the authority to kind of build the law and build the jurisprudence slowly. And keeping in mind the way, data is being used today. I mean, nobody was talking about AI a few years ago. Now we are only talking about AI. Um, but one problem area here is that most of the powers of delegated legislation is with the central government and not with the DPPI. So I think that's a mistake, and there's no real sanction to the Data Protection Board of India to discuss with stakeholders, hold events, release consultation papers, give guidances and so on, which is so much a part of the way EDPB functions. And so I think that's a kind of missed opportunity. And perhaps the central government might delegate more powers to them over time.
Of course, it's a work in progress, and it's clear that the approach in India has been quite flexible in trying to see which is going to be the best approach step by step by seeing what's happening, which is still very interesting. Of course, in other countries, we see authorities and DPA having a central role indeed in issuing even documents that can drive. But you mentioned that there are some examples we should already be looking at, like the DPB in the EU. There might be others, so it's going to be interesting to see how things proceed. Going back to our topic of the day, one of the two deadlines, meaning the first one, which will be in November 2026, if I'm not mistaken. You've been speaking about the consent manager. What's this role about? Because, from the EU perspective, we all know the data protection officer, which I feel it's close but different at the same time. We heard that consent is the key in India in order to process and use personal data. So this might be strictly related to the name of this role.
Right. So they've developed this concept of a consent manager. I think it's a very good thing, particularly when you consider such a huge economy of small and medium scale businesses, which would just find it very hard to implement a consent mechanism. So what the consent manager is, it's really a third party which will come in and manage consent requirements for a data controller. So the consent mechanism itself, you need to have logs that show that the consent was obtained, what it was obtained for. There are rights of data subjects to withdraw consent. So then you've got to take that also into account. So essentially, the consent manager is a third party technology provider who would implement the consent mechanism. And you don't have to use a consent manager. You can if you want to. If you want to implement the consent mechanism yourself, you can do that.
Perfect. And quick but practical question: how does it work to register? It's an online platform or it's a long process?
They have to work that out. I'm presuming it will be an online
Okay.
process.
Okay, perfect. I think we more or less have the frame on the actual stage and what is going to be required in the future. We were mentioning the other deadline, which is the one of the law we were speaking about, which will be in almost 1 year and a half, about May 2027, we said. Based on your experience with those timeframes we have been speaking about, what should company dealing with India, and maybe we should mention who are the companies that should be looking at it. If this has extraterritorial application, it might be interesting. And based on that, what should they look at and what should they do in the coming year and a half in order to make sure they are compliant with the law in India?
So I'll draw a distinction between a multinational or a company that's, complying with data privacy rules or laws worldwide, because they are obviously in a more prepared state, versus Indian companies doing business in India and who've basically never complied with the data privacy law before. So for the latter one, there are multiple stages involved. To start with, you've got to do some data mapping to find out what data you're collecting, what you're collecting it for, who is processing the data, who has access to data, where is it stored. So I think that's the first step. The second step is you look at that and then you ask yourself, okay, this is all the data we're collecting, but how much of it do we actually need? Because as a general rule, the more data you collect, the more the law will apply to you. So perhaps there's a lot of data unnecessarily collected, so you can maybe exclude that. And then you move on to the next stage, which is now you know what data you're collecting and for what purpose. So then you draft your data privacy policy or notice. And then the next stage after that would be to implement, where you need a technology partner who will, be able to implement the consent mechanism, be able to, track your data, make sure that data is used only by persons who are entitled to use it and for purposes which are mentioned in the notice. And then finally, I think data security, making sure that the data is secure and you're complying with the regulations on that too.
Perfect, Stephen. That's absolutely clear. I also understand that for companies coming from abroad, the tendency is that by being already compliant with other laws, it will be a bit easier for them to then be in line with the Indian one. But of course, it's, as we were saying before, it's a progressing law, so it's always good to keep an eye on what's happening in order to be ready to move and to react in case of new requirements. And we underline, I think, the quite stringent ones on the data breach part or cyber crisis part of the law in India, which are very interesting and that we have been discussing also in the past because of that. Stephen, we are running out of our time, so I would really like to thank you for being with us today and for giving us this overview. It's been a pleasure as always, and I very much look forward to host you again in the future with some more updates from India. But thanks for being with us, to you and also to our audience.
Thank you, Alessandro. Always good to talk to you. I do think that there are still more rules and notifications to come. Some things are still not implemented in the statute. And so when that comes about, perhaps there'll be an opportunity for an update.
Looking forward to that. Thank you, Stephen, and bye, everyone.
Bye, everyone.